SJC-12628 in the matter of Neil Anderson.
Mr. Anderson, good morning still.
Yes, good morning. I'd like to bring to the attention of this court that I, as the complainant, I've suffered constitutional violations when I tried to submit a complaint against a judge that's in Superior Court. What happened was I eventually ended up able to file it under General Law 211(3) subsection 13, judicial misconduct procedures. When I filed it, I put all the supporting evidence that supports my claim that the judge actually fabricated evidence to obstruct justice. I was hoping under my First Amendment, allowed to have this to be heard in a court, to show my half of what actually took place and how my constitutional right was violated under the First Amendment. Furthermore, under the 14th Amendment, my Constitution was violated in two areas. One, due process. I was never allowed the due process to show of this complaint, that it should have been gone over due to the seriousness of it, that a judge committed a serious crime. With that being said, I also was denied equal protection of the law. And I'm going to say this with the equal protection of the law, is that if I was a part of the bar, they would take me serious. If I went to the Massachusetts Commission on Judicial Conduct, they would take me serious. But furthermore, when they didn't take me serious and I tried to appeal with them and I tried to show the criminal aspects of the case, because I made a mistake being a layman. What happened was I showed the progression of bias, what Judge Kane was doing at the time, and what ultimately became that he had to fabricate evidence in my case. And it showed a prejudice right through this, but everyone stuck to the prejudice aspect of it, starting from the Commission on Judicial Conduct. And they said that I should do it under a Rule 30. It's not a Rule 30, it's a complaint. I consider this case as much like the Annie Dukin case, where she fabricated court documents and they were not true, such as what Judge Kane did in this case here to obstruct justice, to support his claim to dismiss my Brady issue. You know, it was quite extensive as to how everything progressed in this, and it was so suspicious to me. When Judge Kane took the case from another judge, I ended up, this is what happened, is that I had a suppression hearing in front of Judge Kane surrounding a motor vehicle stop. The Commonwealth could never provide a police report until 4 years later, until we had a suppression hearing. We are forced to have a suppression hearing. And so in being forced to have that suppression hearing, we got the police report that day. It showed in there that he said that he stopped me for a motor vehicle violation. And he also testified at the suppression hearing, the only reason why he stopped me was for a motor vehicle violation. With that being said, I want to go after his probable cause as to why he stopped me. And he said that I didn't have a tag on the number plate that showed the expirement of the number plate. With that being said, they lost the truck. We found out that they lost the truck, they lost the plate, they never could come up with a motor vehicle citation. Under the Massachusetts law, no fix-it law, Mass General Law 90C, Section 2 and Section 10 clearly shows that when somebody has a motor vehicle citation, even if it was destroyed or it wasn't written right, that has to be a paper trail from the registry to the police station and back to the registry again under the no fix-it statute. That sparked my interest because the Commonwealth at no time could ever come up with an actual motor vehicle citation, a carbon copy of it. In the motor vehicle citation, you got the original and you got 4 copies. There should have been a copy somewhere. The only way that they could come up with one is through a computer-generated one. And back before they were doing computer-generated citations, and they amended the law in 2016, a physical document had to be shown. It was not, we did it through a computer. In light of that, suddenly Judge King calls me out of a hearing on a Brady issue, calls us out of a hearing because he talked to Judge Connors, and he wanted to get some background on this, Judge Connor, because we filed a Brady. With that being said, Judge King basically said, send that case to me. We go into a civil session where he's sitting, and he's basically, after saying, well, what's this got to do with this? And we talked about the truck, the number plate. We had the opportunity to raise the issue that they could never show a motor vehicle citation, which the officer says he gave me. That was his probable cause to stop me. With me saying that, I lost my train of thought for a moment there. Give me a moment. When he was supposed to have done that, this should have been a paper trail again, like I said. And with Judge Kane, he suddenly comes out of the clear blue and says that he has a document from the registry saying that there was a ticket. He allegedly sent a court order to the court. Well, when you look at his court order, it's not signed, it's not dated. How can we assert that this is an actual court order? The person who's getting it, there was never any cover letter as to who did the research and tried to look for this alleged citation. With that being said, I had nobody like I could call to the bench and say, well, did you copy this from a carbon copy that derived from a motor vehicle citation? I never had that opportunity. So it was very strange and mysterious as to how Judge Kane did this. I ultimately had to go to the Commission on Judicial Conduct. And again, I'll say this again. I made the mistake of showing the progression as to how Judge Kane became biased and ultimately prejudiced in the case. And there was 2 prongs. There was that and the criminal aspect. Everyone stuck to the criminal aspect of the case. I mean, didn't stick to the criminal aspect. They looked at the issue of his progression of becoming biased. They said it's an appealable issue. From that point on, I went to the single justice, from what I understand, is of my county, Judge Judith Farrakhan. I brought that to her attention, filed a complaint, letting her know. And I did that for the reason is this. Under professional conduct, 8.3, it says in short, that if an attorney or a judge is aware of another judge did wrong, they are supposed to act on it. They're supposed to bring it to the court's attention, bring it to the commission. I was hoping when I sent this material to Farrakhan that she would say, oh, I have to report this. I have to do something with this. It was never done. She gave it to her attorney, which is in the blue brief. She gave it to her attorney, and she just blew it off that I should do an appeal under Rule 30. It's a complaint. It is a complaint. It's a criminal complaint that I'm asking to bring under my First Amendment, to bring and to show to the court, and not only through my First Amendment, is to be heard in the court on the criminal aspects of my First Amendment and how my 14th Amendment was being denied under due process. But I have to say that this is, of course, a different case from everything else. There's no pro se litigant ever bringing charges against a judge. I believe I'm the first on this, to this magnitude, and with the evidence that supports this. With me saying that, I brought it to Farrakhan. She didn't do nothing. As a matter of fact, everything that I did in this case to prove that I did exhaust my remedies, I did return receipt. I even sent one to you, Judge, saying, I have this issue. I need to have something done with it. I sent it to you, Chief Justice. And ultimately, I never got a response. So I write the court back, and I went to to the clerk of courts. I says, listen, I sent this, and here's a copy of my return receipt. And she goes, oh, we didn't get it. Okay, I'll give you, could be an oversight, nobody's seen it, we're gonna move on. It was assigned in front of the in front of the single justice, which the single justice never, at no point in time, looked at the criminal aspect of what took place and how Judge Kane came up with this evidence. I ultimately had to go to the registry under the Public Information Act, and they said there was never a motor vehicle citation there.
Okay, I'm afraid that your time is up, but we
Thank
do
you.
have your papers.
Thank you, sir.
Ms. O'Neill, do you wish to be heard?
Certainly, Your Honor. Good morning, Your Honors. May it please the court, ADA Mary O'Neill for the Commonwealth. We'll be brief here. I'll be brief, Your Honor. The petitioner, Mr. Anderson, has failed in his burden of proving that he has lost out on a substantial right and that whatever he is alleging could not have been remedied in the normal appellate or trial process.
Now, has he filed a Rule 30 motion for new trial?
No. I'm not going to go into great detail unless the court wishes me to do so, but what Commonwealth would like to state for the record is the petitioner's argument appears to be an attack, or whatever the court wishes to frame it, on retired Superior Court Judge Robert Kane. There is nothing in the record to support such an allegation. If the petitioner were correct in his assertion or had a factual basis for his assertion, that could have been the foundation for an appeal, which was not done. And I think the most salient fact here, and where the Commonwealth intends to wrap up unless the court has questions, the most salient fact here is that on December 5th of 2011, Mr. Anderson pled guilty to these charges. If the basis for his argument is that these charges were spurious or that he should not have been convicted because Judge Kane apparently forged some documents, then that could have been addressed in the normal course. But again, there is no factual basis for such an allegation, and that Justice Gaziano was absolutely correct in his ruling that this particular petition under 211.3 should be denied, and to have done so without a hearing. Unless there's more, the Commonwealth will rest on its brief. All right. Thank you, Your Honor.
Very, very, very.